is Bridget Mackay. I'm an attorney and I practice exclusively in the area of wills and trusts and estate planning. And this is my video blog. In this month, in the month of January 2012, we are addressing your New Year's resolutions to get a will or a trust done. I spoke about wills in the last blog, and this one I want to address to living trusts. People often call wondering what a living trust is and whether they need one. So hopefully we'll have some basic information here to make that decision. What is a living trust? What does it do? It does about the same thing as a will in the sense that it can transfer your assets at death to your heirs. But it is different than a will. It has an extra feature component to it in that you avoid probate, or you avoid having to go to court in order to transfer your assets or your stuff to your heirs. And as such, it often is less costly of an instrument to use to plan for your eventual death. Because you avoid that whole probate court situation, which, you know, as everyone knows, anytime you have to go to court, it costs money. So the other piece of a trust that is different than a will is that it also kicks in if you're incapacitated for a long period of time. Let's say you have a stroke or you develop Parkinson's disease and you can no longer manage your financial affairs, and a durable power of attorney is not enough. You need someone in place controlling your assets. Then a trust allows for your successor trustee or for someone to help you and step into that role, and you get to choose who that person is. So why should or who should have a trust versus a will? Well, two basic requirements in my opinion is if you have a house or you have assets that value over $100,000, you should opt for a living trust rather than a will. It's kind of that basic. How does a trust work? Well, when we create a trust for you, instead of a will where we create the document and say, this, I want, you know, my house to go to Susie, my child, with a trust, we say all of those things, but there's a second step in which we take all of those assets and we transfer them into the trust by title. So, for example, Jim and Judy Smith owned a house and they did a trust. We take the deed of that house, which was once owned by Jim and Judy as, you know, joint tenants, and we change the name of ownership to that house as Jim and Judy Smith, trustees of the Smith Family Trust. Then at their death, it saves that house from going through probate or the court process to transfer. So, and also it allows, if Jim and Judy get Alzheimer's or lose their capacity, then their daughter Susie can jump into the role as trustee and take care of them. So obviously there's some subtopics here, but that's the basic design of a living trust and how they're different from wills. So if you have more questions, always contact our office and we'd be happy to help.